the biggest misconceptions in commercial law is that once a contract is signed, the words on the page are absolutely final. In most cases, that's true. But what happens if both parties intended one thing, the drafting accidentally says something completely different, and one side stands to make over $100 million from that mistake? That's exactly what happened in the recent Supreme Court of New South Wales decision in FX Group Holdings Pty Limited versus Perpetual Trustee Co Ltd. And it's an important reminder that courts don't simply read contracts in isolation. They also consider the commercial purpose of the agreement and, in limited circumstances, can even correct drafting mistakes. I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is my AI avatar presenting from a script that I've personally written and approved. Today I'll explain what happened, why the dispute arose, and the important lessons every business owner should take away from this decision. The dispute arose from the sale of Pepperstone, one of Australia's largest online foreign exchange trading platforms. Back in 2018, a private equity firm agreed to sell its investment to FX Group Holdings. Rather than obtaining finance from a bank, the purchaser was funded entirely by the vendor. The agreement was that the loan would be repaid over a 5-year period using dividends generated by the business, but there was another important part of the commercial deal. Once the loan had been repaid, the vendor would also receive what the parties described as super returns. In simple terms, once the debt had been paid back, profits above a certain threshold would be shared equally between the parties for 4 years. That commercial arrangement was originally documented in the heads of agreement. The problem arose later when the formal share sale agreement was drafted. Everything appeared to operate normally until the loan was repaid in 2022. That's when the parties realized they interpreted the contract very differently. FX Group argued that the wording of the share sale agreement allowed them to deduct not only the agreed profit threshold, but also the entire loan repayment and interest before calculating the vendor's entitlement to super returns. In practical terms, they argued the loan repayments could effectively be counted twice. If that interpretation was accepted, the vendor would lose more than $100 million it believed it was entitled to receive. Not surprisingly, litigation followed. The Supreme Court rejected FX Group's interpretation. In doing so, the court reinforced 3 important principles of Australian contract law. The first principle is that contracts aren't interpreted by looking at individual words in isolation. The court considered the wording of the agreement together with its commercial context and purpose. When the judge looked at the entire transaction, including the earlier heads of agreement, it became clear that the parties never intended for the loan repayments to be counted twice before profits were shared. The court concluded that this interpretation simply didn't make commercial sense. The court also discussed an important legal concept known as correction by construction. Sometimes a contract contains wording that, if interpreted literally, produces an absurd or commercially irrational outcome. In those situations, the court may interpret the wording in a way that better reflects what reasonable business people would have intended. Importantly, this isn't the court rewriting the contract. It's the court interpreting the words in their proper commercial context to avoid a result that the parties could never realistically have intended. The judge indicated that even if FX Group's literal interpretation was available, the court would still have interpreted the clause differently because the alternative produced an irrational commercial outcome. The court also considered the alternative argument of rectification. Rectification is different from interpretation. Instead of asking what the words mean, rectification asks whether the written contract actually reflects the agreement both parties intended to make. The evidence showed that throughout the negotiations, both parties consistently intended the commercial arrangement recorded in the original heads of agreement. Drafting of the share sale agreement simply failed to reflect that shared intention. As a result, the court held that if the contract did contain the meaning argued by FX Group, it should be formally corrected through the equitable remedy of rectification. Perhaps the most interesting part of the decision involved what happened before the contract was signed. The evidence suggested that representatives of FX Group identified the drafting issue during negotiations. Instead of raising it with the vendor, they remained silent. The court found that allowing the other party to sign a contract containing a known drafting mistake, while intending to benefit from that mistake later, was unconscionable. The law does not permit a party to knowingly take advantage of an obvious drafting error simply because it appears in the final contract. First, never assume that because wording appears in the final contract, it accurately reflects the commercial deal. Financial formulas, payment mechanisms, earn-out provisions, and profit-sharing clauses should all be tested using real financial examples before the agreement is signed. Second, keep your negotiation documents. Heads of agreement, term sheets, draft agreements, and important emails can become critical evidence if there's ever a dispute about what the parties actually intended. And finally, if you discover a drafting mistake before a contract is signed, don't stay silent hoping you'll benefit from it later. As this case demonstrates, the courts may intervene where one party knowingly exploits an obvious mistake. The FX Group decision is an excellent reminder that good drafting matters. While courts have powers to interpret contracts in their commercial context, and in limited circumstances rectify genuine mistakes, litigation is always far more expensive than getting the drafting right from the beginning. At Leo Lawyers, we regularly advise clients on commercial contracts, shareholder agreements, business sales, and complex contractual disputes. If you'd like tailored legal advice, you'll find our contact details in the description box or visit us directly at leolawyers.com.au. Thank you for watching, and I'll see you in the next video.